Chapter 11, Real Estate Contracts, page 193. Everybody ready there? Let's get going. Let's do this, shall we? Dooby-dooby-doo. So chapter 11, Real Estate Contracts. This chapter is not just going to be about real estate contracts. It's going to be about general contract law as well as real estate contract law. Remember, we got to follow multiple laws. And you've got to follow general contract law as well as real estate contract law. So in this chapter, we're going to talk about the 4 essential elements of a valid contract, including the effects of a statute of frauds. We're going to identify different types of contracts and issues that affect validity of contracts. We're going to explain various contracts used in the real estate business as well. So what is a contract? A contract is a voluntary agreement between 2 competent parties to perform some legal act, but it has to be supported by some form of legal consideration in order for it to be valid in the eyes of the law. The parties have to be exchanging something of value, whether it's goods, money, or services. So let's highlight there. Contract may be defined as a voluntary agreement between legal competent parties to perform or refrain from performing some legal act that is supported by legal consideration. That's the compensation we receive. All right. There are 4 essential elements for any contract to be valid that are required. You have to have competent parties, offer and acceptance, consideration, and legality of the object or purpose of the contract. Has to be for a legal purpose and not against public policy. So let's highlight, and let's write the number 4 in front of that, and then let's highlight there's 4 essential elements to a valid contract. And let's just highlight the titles of each: competent parties, offer and acceptance, consideration, and legality of the object. And then we're also going to highlight what the 3 forms of legal consideration are that we're going to go over, and then highlight that parole evidence rule. All right, so competent parties, you have to be at least 18 years of age or older in New Jersey to be a competent party. You have to, because anything younger is a minor, considered a minor. You have to be of sound mind, sane, sober adults with no mental disease or defect. All right. If you're under 18, a contract is voidable. You can enter into a contract with a minor, but it's not recommended because they're not a competent party, and the contract can be voided by the minor if they choose not to be in it anymore. That's the end of it. You cannot enforce a contract against someone who is not a competent party. However, they can enforce it against you because you are. So it's not very wise to enter into contracts with people who are not competent parties. Now, for exam purposes and exam purposes only, I've been bringing this up to the state for the longest time that they should change their exams. They should remove it. You know, PSI is apparently unaware that they even got questions on their exams about this stuff. Or they're just playing ignorant, or they just don't know, or I'm not talking to the right people there. I don't know. And I bring it up to the Real Estate Commission as well. But for exam purposes and exam purposes only, not in real life, but for exam purposes, because you get sometimes questions on state exam about this stuff, that a minor can be considered an adult where a contract will be legally enforceable against them if they're married. All right, so this is for exam purposes only. A minor under the age of 18 can get married with parental consent. That's no longer true, actually. Here, hold on a second. Let me put a link to that correction. Let me see if I could locate that. I know it's on a coming slide somewhere. That's actually on this slide already. Under no circumstances can a minor be considered an adult. All right. So for exam purposes and exam purposes only, a minor under the age of 18 can get married with parental consent and would be considered an adult. So contracts with these married minors are considered adults, so contracts are legally binding. But let me just focus on this, that no longer allowed in NJ. Okay. So in real life, this is no longer allowed. Previously, you were able to get married under the age of 18 with parental consent. I think you could get married as young as 16. I'm not sure the exact age, what it was on there, but that's no longer the case. We had a lot of these children rights advocacy groups that were able to pass laws that removed that exception, because we were seeing that in some cases this was just a way for people to abuse children. Granted, they weren't allowed to do it at obscenely young ages, but still 16, selling your child into marriage, may be common in some cultures. And, we're a melting pot here. We get people that come from all over the world, and sometimes they want to, bring their own ways here. And, but that is child abuse, So it aided in human trafficking. And this is actually passed during the Trump administration, too. Trump had nothing to do with this. This was a child advocacy group here in New Jersey. But Trump did a big push when he was president for all kinds of anti-human trafficking and child protection things that he that was one of his strong suits there. He actually even, this is why on websites like Craigslist, you don't see classified ad sections anymore, because he pulled it down. Those classified ad sections pertaining to dating and such, because those were full of prostitution, and it was just a way for human trafficking to try to sneak by. So he made it so that these websites that, even though they were not engaging in human trafficking, those that enabled it or turned an eye to it can be held liable. So all of a sudden you saw all these websites taking down their classified ad sections for dating and massage services and stuff like that. A lot of that was human trafficking and minors and prostitution and such. So we had our own group here in New Jersey. They were able to change this law. And if I click on this, I could show it to you. That New Jersey marriage age requirement law. Let me see. In June 2018, New Jersey became one of the first states to ban child marriage. And now there's a clear minimum age of 18 with no exceptions. The main provision of New Jersey's marriage age requirement laws are listed in the chart below. All right, so it's basically, there's under no circumstances, even with parental consent, can a minor get married in New Jersey any longer. However, there may be exam questions on this, and the exam question, if it asks, a child under the age of 18, if married, can be considered an adult, and the contracts can be legally enforced against them. Okay? But in real life, that's not the case anymore. Okay, so offer and acceptance. Mutual, also known as mutual assent. is when the parties are in agreement on all the terms of the contract. It's said that they've come to a meeting of the minds. We're on the same wavelength now, right? So we've come to a meeting of the minds when we're in agreement on all the terms of the contract, and we're aware of all the terms of the contract, and we understand all the terms of the contract. So the parties are aware of and in agreement to all the terms, which must be clearly stated and understood by the parties. Okay, so for school exam focuses more on the financing aspects of that meeting of the minds, where the parties are in agreement on all the terms. They kind of focus on the financial method, the financing. So the school definition for answering the school exam question is when the meeting of the minds means when the parties are in agreement on price, down payment, and financing method. How are you coming up with the rest of the money to complete the purchase? And then we have consideration, something that's what the parties give or receive from each other in the exchange. It's the entire purchase price. And there are three legal forms of consideration. Legal tender, that's money, cash money, or a mortgage loan, or an exchange of something of value, goods or services. I'll give you this in exchange for that, or I'll do this for you if you do that for me, or give me that. And love and affection. Courts have held that the gift of love and affection is something of value that the parties can give or receive from each other. So somebody can give you a gift of real estate because maybe your family and they love you, right? Now, in New Jersey, in order to record a deed in the public records, you have to state what the full purchase price was. But in the event of love and affection, you could put down $1 as long as it's accompanied by a note that says, in fact, that this was a gift. And in tax records, sometimes you see that as well, that it may be listed as $1 sale sometimes. That may be because there was no exchange. It was just a modification to the ownership. Maybe somebody was removed or their name was corrected. Or they refinanced their loan. So then they'll just put down $1 there. And then we have legality of the object or purpose for the contract. The contract cannot be against public policy or for something illegal. So may not involve an illegal purpose or substance or object. Whatever you're selling must be legal. You cannot have a legally enforceable valid contract to sell crack, because it's a controlled substance. It's an illegal drug, right? If you can't have a legally enforceable contract to kill somebody because murder is illegal. You get the gist of it, right? So there's 4 essential elements to a valid contract: competent parties, offer and acceptance, consideration, and legality of the object. You need to memorize that for exams. Also know that a person under the age of 18 can be considered an adult if they're married, but that's only for exam purposes, but not for real life anymore. And then you need to know the 3 legal forms of consideration: legal tender, exchange of value, and love and affection. Okay. And also, to be valid, contracts can be oral or written, but for real estate sales, they have to be in writing according to New Jersey law. You cannot have a verbal contract to sell real estate. It must be in writing. Now, the parole evidence rule. Now, if we're just talking general contract law, the parole evidence rule states that if you got one party who has a verbal contract, a verbal agreement, and another one who's got it in writing, they can produce evidence. The parole evidence rule says that the one who's got the evidence will take precedence over the one who does not. Does that make sense? So the courts will just kick out the one that's only verbal because they can't prove it. It's he said, she said, versus somebody else who steps forward that has a contract in writing. So that's what the parole evidence rule states, that written contracts take precedence over oral agreements or promises. So a judge would throw out of court the verbal contract, the verbal agreement, in favor of the one who has it in writing, because they got that proof, the evidence. Parole evidence rule. Make sense? So anytime a contract's modified or you make any changes to it, it must be agreed to by all parties in writing. Otherwise, you just voided the contract. Licensees must not make any changes or additions to a contract after both parties signed it, because that would be practicing law without a license. But say one party signed the contract and submits it over to the other side, and they say, nah, we're not going to accept that, not unless you raise the price, your offer price. So then we cross out the price there and we put in a higher price, and then the seller signs it. But then they got to go back to the buyer because the buyer didn't sign off onto that change yet either. So anytime we do touch a contract and make a modification to it, we need all parties to initial or sign next to each and every place where you made a change on the contract. So an amendment is making a change to a contract. An addendum is when you add something to it. It even has the word add in it, right? So an amendment is when you make a change or modification to a contract. An addendum is when you add something to the contract. Either way, both parties have to sign it. If only one of them signed it and we do add or make changes, all parties need to sign off on those changes or additions. But remember, once the contract's been signed by everybody, we, as real estate agents, cannot make any amendments or addendums to a contract. Only an attorney can, because that would be practicing law. So let's write this on the side next to amendments and addenda. Licensees must not make any changes or additions to a contract after both parties sign it. This is practicing law without a license. And let me know when you guys have that, please. Licensees must not make any changes or additions to the contract after both parties signed it. This is practicing law without a license.
Okay.
Okay, everybody okay?
I got it.
Good.
All right. So the real estate commission rules, we have to, as real estate licensees, we follow both contract law, general contract law of the state, but also licensing laws. So the real estate commission rules state that for us to be entitled to a commission, a real estate broker cannot be paid unless they have some sort of authorization in writing by our clients or customers to be entitled to earn a commission. So that agreement must be in writing. And we usually do this with a listing agreement, exclusive buyer agency agreement, transaction broker agreement, or some sort of referral agreement that is signed between brokerages. So it is signed by the consumer. Witness's signature is not required in order to make a contract valid, by the way. And anytime we sign a contract with a consumer, we must give them a duplicate original of it immediately. That's a copy of the contract with original signatures. So it's basically multiple originals. And this applies to the sale or lease contracts as well. And no matter who the broker is working for the seller, buyer, landlord, or the tenant. Statutes of frauds. Anytime we hear that term, it requires something be in writing. So this is what we need to know. What's in this box here? Sales contracts for real estate in New Jersey always have to be in writing. However, a lease, if no real estate agents involved, a lease must be in writing if it's 3 years or more. But keep in mind, if a real estate licensee is involved, it doesn't matter how long the length of the lease is. It always needs to be in writing. And leases can be recorded if they're 2 or more years. So all real estate sales contracts have to be in writing. Leases must be in writing if they're 3 or more years, and they can be recorded in the public record if they're 2 or more. That's the takeaway from this that you need to know. But it's always extremely risky to rely on verbal contracts alone. How do you prove it, right? Remember, us as real estate licensees, we also have to follow state law as well as the administrative code, which is the Real Estate Commission rules. 4515 is the New Jersey statutes. 11.5, Title 11, Chapter 5 are the statute or the administrative code, the rules and regulations of the Real Estate Commission. So we got to follow all that stuff. And it basically says we must never have verbal contracts. Everything that licensees do must be in writing. So let's highlight that. New Jersey statute of frauds. And then we're going to write in there, leases longer than 2 years can be recorded. And let me know when you're done with that.
Got it.
Okay. So contracts can be express or implied.
Can you hear me?
Yes.
Yeah, sorry, a question. Why would you, what's the benefit of recording the lease? I'm just wondering.
If
It
you
can be recorded.
if you have a long-term lease, like maybe for commercial property, I'll give you one example. Like in Edison, where the ShopRite is there in Edison? That's shopping center over there on Route 1 where the ShopRite is.
Yeah.
You got the anchor store, which is the ShopRite, and then you have a bunch of other stores within that complex there. There's one guy that's leasing all of the stores. And then he's allowed by the owner to sublease it. The owner doesn't care because as far as they're concerned, they're getting paid rent on all the units, whether they're vacant or not. Because one guy is leasing it, he's responsible for the leases on all of them. However, they're allowing him to sublease those units. He has a long-term lease. I don't know how long of a lease this guy's got, but he's had that lease there for at minimum 20 years already. But he would want to record that lease in the public record to put the world on notice that he has an interest in that property. So in the event that the owner dies or they sell it, that the new owners are not going to be able to just kick him out or change terms or anything because he recorded his long-term interest in the property.
Got it. Makes sense. Thank you, Victor. Yeah, that's perfect.
Okay. So contracts can be express or implied, unilateral or bilateral, executory or executed, valid, unenforceable, voidable, and void. We're going to go over these terms now, see what they mean. So let's first do the highlights here. In an express contract, the parties state the terms and show their intentions in words. An implied contract is demonstrated by their acts and conduct. Bilateral contract, both parties promise to do something. Here's the litmus test to make sure something is a bilateral contract, so just underline that. I will do this and you will do that. That shows that both parties are required to do something, so therefore it would be a bilateral contract. It would be a unilateral contract if they had the litmus test in there that says, I will do this if you will do that, which appears that they may have taken that out of this book, this version book, and highlight their definition, but I got better definitions on the next page. So let's just do these highlights and then we'll go to my notes on the next page. Let me know once you got all the highlights.
Good.
Everybody good?
Good.
All right. So an express contract lays out all the terms expressing them in words, leaving nothing to interpretation. Those words are usually placed in writing. That's an express contract is where you express yourself. You're expressing yourself in words. Okay. So you're leaving nothing to interpretation because it's being fully explained. However, an implied contract is one that is created by one's actions rather than their words. So therefore, it could leave some things to interpretation. Some examples of this would be a lease that expires, but the landlord still accepts the rent check from you, implying that they're okay with you remaining there. But because you have no new contract in writing, does it go according to the old terms or what's the deal? You know, it could leave some things to interpretation and can cause some confusion there. Now, Here's another example of an implied contract. If a bank accepts a payment from an owner after a foreclosure process begins, this could be interpreted by the courts that there may be some sort of an agreement between the lender and the owner for an alternate form of repayment to get caught up on the outstanding balance, especially if they tell the court that that's what's going on, because that implication of them accepting a partial payment may create that implication that there was some sort of an agreement. So the payment would serve as the borrower's evidence for such a claim. And this is why banks will usually not accept any form of partial payment from you if you're behind on your mortgage payments and they already started the foreclosure process. So they'll always be doing like collection calls. You're late on your payments. Can you make a payment today? Can you make even a partial payment, any kind of payment? They're doing their collection. Once those collection calls stop and you even call them to try to make a payment and they won't accept it, they already started the foreclosure process. They will not accept anything less than the full amount owed, including late fees and costs, etc. Because it could create that implied contract. Here, some other examples of implied contracts that are not real estate related. You go to a restaurant, you sit down and you order food. It's implied that you have the intent on paying for it. So that would be a contract in the eyes of the law. You go into a restaurant, you order food, you sit down, you start eating for it, you got to pay for it. You know, it's an implied that you are going to pay for it because you ordered food and nobody's giving it to you for free. Unilateral contract, one party's required to do something, the other has an option to act or not, but they do not have to. So any kind of contract where somebody has an option to do something or not would also need to be prepared by attorneys, by the way. So an example of a unilateral contract is a one-sided agreement or promise. So a lease with an option to buy. The owner agreed to lease you the property and they're giving you the option to purchase it at a predetermined price by a predetermined deadline in the future. Do you have to purchase the property from them? No. You have the option to. But if you exercise that option to purchase it, the seller has to go through with the agreement and sell it to you for that agreed upon price. So I will do this. If you will do that is the litmus test to determine if something's a unilateral contract or not, which is usually one that gives somebody an option to do something. A bilateral contract, on the other hand, both parties are required to do something. I will do this and you will do that. All right. It's not a lease option, but a lease purchase contract would be an example of that. I'm going to lease the property from you, but I'm definitely going to purchase it by a predetermined deadline at a pre-agreed upon sales price. So that's the difference, lease option or lease purchase contracts. Here, another example of a unilateral contract. A law enforcement agency offers a monetary award for anyone who aids in the capture of a criminal that leads to their arrest. Are you required to help the law enforcement capture the criminal? No. But if you do, they got to pay you the reward. That's an example of a unilateral contract. Let's throw out that beginning of class attendance poll out there. If everybody could answer that poll, please. We have one more. One more person needs to answer that poll. Contracts can be executed or executory. This refers to the status of the contract. Executed contract can be one that had been signed by everybody. Fully executed contract, executed contract is one that is signed. A fully executed contract is one that is signed by everybody. And then we also have the terms that could mean be relating to the status of a contract. A fully executed contract means all the terms of the contract have been completely fulfilled and there's nothing left to do. An executory contract could be one that is still in progress and we still have things that have not yet been done. Tory, it's still in progress. All right. So, but for exams, you're probably not going to get either one of those. I never heard that term executory until I started teaching class, to tell you the truth. Executed, fully executed, you hear that all the time. And it doesn't even usually pertain to the status of the contract. That's something they probably teach attorneys in law school to use that lingo, but I never heard them use it. We usually, when we use executed and fully executed, it's referring to whether the contract was signed. Okay. Okay. Jeez, no participation today, huh? All right.
Waiting for the coffee to kick in.
Oh my
Alright.
gosh. Gotta put some jumper cables on that coffee. All right. So there we go. Here's what we will do. Executed and executory contracts. Over here in this section, I put the box around it and I just wrote status of a contract because this is talking about the status of the contract. And down here, it's pertaining to actually it being signed. So let's highlight an executed contract can be a signed contract. A fully executed contract would be one that's signed by all parties. Waiting for the coffee to kick in. I'm sipping my coffee whenever I get a chance between my constant jibber jabbering. Need a minute to suck down my cup too. All right. Validity of contract pertaining to contracts being valid. A valid contract is one that contains all of the essential elements of a contract. What are all the essential elements of a contract?
Competent parties offer an acceptance, consideration, and legality of object.
Yeah, legality of the object or purpose of the contract, correct. So you need to know those, you need to study those, you need to remember those for exam. But yes, those are the 4 essential elements that would make any contract valid. So a valid contract contains all those essential elements. Therefore, a void contract, it's kind of a self-contradictory term because a void contract isn't a contract at all. It's either one that's missing one of the essential elements or one that has already been canceled. Like a contract to commit a crime would be void because it's missing that essential element. It's not for a legal purpose. It's against public policy, right? So a void contract, a voidable contract is one that seems on the surface to be valid, but can be canceled or rescinded by one of the parties. Like, well, we'll give you some examples on the next page, but like a contract with a minor, right? Contract entered into with the minor is usually voidable. That's why I got that highlighted. They also give you other examples, like a person who signs a contract under duress or undue influence may also have grounds to void a contract. That means under pressure or intimidation or force. An unenforceable contract, on the other hand, is one one where neither party can sue to force performance. Do we actually have those words anywhere here, though? No. But they do give an example, like a person who was drunk agrees to buy a friend's property. Maybe that friend is also drunk. And because neither party was a competent party at the time of signing, the contract's not enforceable. But if they both sober up and want to continue being in the contract, there's nothing to stop them from doing so. This type of contract is known as being valid between the parties. Neither one of them can sue to force performance because neither one was a competent party at the time they signed it. However, they choose to be in a contract with each other still. That would be valid between the parties. So, valid contract meets all the legal requirements to be enforceable. A void one can be disaffirmed by one of the parties. Avoidable, rather, can be disaffirmed by one of the parties. Could be missing one of those essential elements, like a contract with a minor, or by one party's under influence, drugs or alcohol, or one party may not be of sound mind, or undue influence, they're being taken advantage of or being forced and intimidated to sign. Duress, that's what undue influence and duress means. An unenforceable contract, neither party can sue to force performance. However, if they wish to, they could be in contract with each other, and that would be valid between the parties. And a void contract, once again, is that self-contradictory term because a void contract is not a contract at all because it's missing one of the essential elements, or it's not valid, and it's not valid to begin with, or a contract's already been canceled for one reason or another. If you want to snap a picture of that, do so. Let me know. I'll change the slide. So undue influence means you're taken advantage of. So we have to use extreme caution when dealing with elderly people or those who may be under the influence of drugs or alcohol, or have some sort of mental disease or defect, or are on their deathbed or in a hospital. Be very wary of, don't go to hospitals to get people to sign contracts. That's very sketchy, people who have Alzheimer's or dementia, insanity, or extreme cases of bipolar, things of that nature where they could be considered being taken advantage of. Now, be respectful of your seniors, guys. Be respectful of adults, of seniors out there. But you have to be aware that there's the possibility that their cheese is sliding off their crackers, so to speak. And if that's the case, you need to be careful. You may not know. They may seem perfectly lucid to you. Only thing is they think that they're still living in 1930, it's hard to tell sometimes when people are not of sound mind. You can't see what's going on in here. All right, but be respectful of your seniors and of their of those adults. But you may want to ask them a question, like if getting a listing. Is there anybody else that needs to sign contracts with us here today, or is it just going to be us? It may rattle something in their head that they'll remember. Oh yeah, I have my kid is my legal guardian. They need to sign with me or something of that nature. I've done this before, and I've asked this question to people before because I've come across the instance before where I got a listing, and then a couple of days later, I had a phone call from a lady saying, "Yeah, I went to my mom's house and she had all this paperwork from all these different realtors, and she told me that she listed her property for sale with you." I was like, "Yes, I do have that listing." She's like, "My mom's not selling her property. She's got dementia. I'm her legal guardian." She said she's not selling her property. So at this point, what do I do? What do I do? What would you do?
Hire an attorney.
Hire an attorney. No, I'm not going to hire an attorney for my listing. But I got a listing, and I've got this lady calls up, says her mom's not selling her property because she's got dementia and she's a legal guardian and she's not selling her property. So what do I do? So what do I do?
asked her. I asked the daughter if the property is for sale because she's a legal guardian.
All right. Any other ideas? What do I do with the listing that I already have?
Cancel.
Void it.
Is it? At this point, I have no idea who this person calling me is. I know who they say they are. But I don't know who this person is. They could be the daughter, but maybe not. I got to keep representing my client's interest in trying to market and sell that property until somebody comes to me with some kind of documentation showing that they're a legal guardian and that they are going to withdraw that listing.
I need to ask for ID for the daughter.
Not just for ID. I don't care. You could be the legal daughter. You could be the daughter. But do you have the authority? And is your parent do they have Alzheimer's or dementia? And have you been assigned by the court to be their legal guardian or not? You should have some sort of declaration that they've been declared incompetent and that you are now their legal guardian. You should have some kind of paperwork pertaining to that. If you don't, I got to keep representing my client trying to sell the property. Because you may be the legitimate daughter, and maybe there's some drama in the family. The parent wants to sell the property, downsize, move to Florida or something, and you're like, no, I want that property. I want to inherit that property when you die, and there could be some kind of drama like that in the family, So I don't know. I was hired by the owner. Unless somebody shows me that the owner was incompetent and you have the legal authority to act on their behalf, I'm not listening to you. I got to listen to them still. You follow? You got to keep looking out for your client's interest. You can't just trust and believe everything that anyone says, even if that is the legitimate daughter. But she was the daughter and her legal guardian, and she came down with paperwork, and then I had her sign paperwork to cancel the listing. So because of that, after that time, that was my first instance of that. After that, I had instances where I dealt with an older gentleman, and so I asked him. I was like, "Is there anybody else going to be signing contracts with us here today?" And he's like, "Oh, thanks for reminding me. Yeah. Let me get my son on the phone. He just lives around the corner. He'll be here. He has to sign paperwork with us." And so I knew what that was about, because he was listed as the only owner. So I knew what that was about. But see, I was able to stir something in his mind that he was like, "Oh, yeah. Now, people who have Alzheimer's dementia, they may not know. They may not even remember that they got kids. They may think that they're 18 still, but it doesn't hurt to ask. So I made a habit of asking this after that, after it worked, but you got to be respectful of your seniors still, because I've asked this to another senior lady that I went in to get a listing from. And I asked her, I was like, "Well, is there anybody else that needs to sign contracts with us here today?" And she's like, "What are you trying to say?" I was like, "Well, I mean, is there anybody else, listed as the owner and needs to sign documents with us here today? Or are you the only one?" And she's like, "Oh, you're not trying to make any implications or anything that I'm not of sound mind, are you?" I was like, "Oh, no, I'd never." She knew what I was doing, but, she was pretty sharp. But it's a good way to ask it, because you're being respectful. And still, you never know, because it may not jar any memory, but it may. At least you're doing something to try to figure it out, right? And you could have young people that have, forms of dementia or other mental disease, especially these days. The mental health is extremely lacking, or so it would seem if you look on the news at any day of point or time. People don't even know what sex they are anymore. All right. So under duress, that means force, and undue influence means that they're being taken advantage of. All right, so now we're going to coming up on the next slides, we're going to go over performance of a contract, and that we're going to learn that dates are merely guides to follow, and we're going to learn about the phrase "time is of the essence." Sounds important. We're going to learn about the different ways to discharge a contract. We're going to learn about default and breach of contract, and about this term called statute of limitations. So let's start off with the last one, the statute of limitations. Here, you may want to snap a picture of this slide. Statute of limitations is a time limit in which one has a right to assert their legal rights. Now, in New Jersey, there's a 6-year statute of limitations for contracts, foreclosures, mortgages, and cases of fraud. If you actually want to recover the real estate, the property, there's a 10-year statute of limitations in New Jersey. How long are brokers required to keep all records for? 6 years.
6
Years.
years.
Unless it's an expired listing or an unaccepted offer that was made, then it's 6 months. 6 years. And the statute of limitations is 6 years for contracts. I wonder if there's any correlation there. All right, but you need to know statute of limitations, 6 years and 10 years. You may get a question on exam about this, probably. I know you get one on an exam sooner than later, but maybe you may get one on the later contract as well, or test. So let's do the highlights now, page 196 and page 197 about the statute of limitations. Breach of contract, also known as default, is when somebody breaks the contractual agreement without having a good legal excuse to do so. So if you're under a legally binding contract with somebody, if you're in a legally binding contract with somebody, they can't just back out of it or break the terms of the contract. If they do, that's called breach. They're in breach of contract. They are in default of their agreement with you. And therefore, they can be held legally and financially liable to the other party. So that's default and breach of contract. Now, dates in contracts are merely guidelines to help us follow along on what we're supposed to do and accomplish in that contract. But they're just merely guides for us to follow. If you miss a date that's stated in a contract, you're not considered to be in breach of contract. However, sometimes we want these dates to be solid that are in a contract. We want them to have meaning to them. So we could add a time is of the essence order. Now, we usually don't do this. We usually don't use the term time is of the essence. We'll ask an attorney to do that, though. And it's usually if you're the seller's agent and a buyer makes an offer on the property. All right. And they accepted it and they went to attorney review. It's out of attorney review. And there's a date in the contract that says that the buyer has to complete certain tasks by inspections, appraisals, but they also need to produce a mortgage commitment letter. And that date comes and goes, and we never received the mortgage commitment letter. So we need to stay on top of that. Call the other agent up. Hey, your client, I never got the mortgage commitment letter for them yet. Can you send that over? Do you have it? We want to know that they can actually get the loan to go through with it. A mortgage commitment letter is when the buyer slash borrower completes a loan application with a lender and submits all the required documentation they need to complete that application. And then the lender goes through underwriting to review all their finances, and then they commit to giving the loan to that borrower by issuing a loan commitment or mortgage commitment letter. All right, so that loan commitment letter, we need a copy of that. Now, if they say, let me check with the lender, I'll get back to you. And days go by and we didn't hear nothing. So we reach out to him again. Yo, what's up with that mortgage commitment letter? I never heard back from you. Oh, yeah. I was waiting on him. He was going to get it for me. Let me follow up on that. Days go by. What's going on with the mortgage commitment letter? Oh, yeah, he was supposed to send that over. Let me give him a call again. I'm starting to get the feeling that they may be having a problem getting the mortgage. So they may not be honest with me. They may be, even though the other agent's supposed to be honest with the other party, treat everybody fairly and honestly in a transaction, sometimes the agents don't. Sometimes they're scrambling, trying to get their client approved and get them a loan through another means because they can't get it through the current one. So if I start getting this feeling that that's what's going on here, I'm going to call up the seller's attorney and ask them to issue a time is of the essence order to the buyer. So they'll send out a letter that says that they need to produce the mortgage commitment letter by a certain date and time. And if they don't, then the contract will be killed automatically. So it kind of lights a fire under their butt to do something, right? And if they don't get it to us on time, contract's automatically killed. However, be careful. This could be a double-edged sword. What does the book mean by that when they say it's a double-edged sword? Well, because double-edged swords cut both ways. So if they do kill the contract because they don't produce that mortgage commitment letter by that deadline, but then the very next morning they get it for us, comes in, well, contract's already killed. Can the attorneys piece it back together? Sure. But the other side doesn't have to agree to piece it back together or piece it back together exactly the way that it was. They could say, hey, remember we had the home inspections and we want you to do this work and you didn't want to do this work? Well, we'll put the contract back together, but only if you agree to do this work. And if you don't, I guess you could put it back on the market and try starting from scratch all over again, hunting down, trying to find a buyer, and then get under contract, go through attorney review and start all over again. Or we could pick up where we left off, but you agree to an additional term. See, so you could lose a little leverage with that too. So it does cut both ways, that's a possibility. So the term time is of the essence you will absolutely have on exam. It's a strict deadline in contracts that must be met. So let's highlight in the book. Time is of the essence. This means the contract must be performed on time within a time limit specified, and any party who's not performed on time is guilty of breach of contract. So it's a strict deadline in a contract that must be met. Bottom line. Assignment and assuming of contracts or assumption. When one party assigns their contractual obligations to another. Now, usually our contracts, like lease agreements, specifically prohibit assignment of contracts or obligations. But if the other party allows it, you're never relieved of your original obligation. You always remain the primary responsible party to the contract. So if the landlord allows you to sublease, if the new tenant who takes over your lease does not pay the rent, you are still obligated because you're the one who signed the lease with the landlord to begin with. Even though you're leasing to someone else, you got someone else in there to take over your lease. You're never relieved of your obligation to pay the rent if they fail to, or if they breach one of the other terms of the lease agreement. Now, there is a way that you can be relieved of that obligation. It's called novation. Novation is substituting or replacing an existing contract with a new agreement, where the original contract holds no legal force because it's been replaced. You could also, instead of just replacing the contract, you could replace the parties named in the contract. This is called novation of the parties, where you're substituting an old person that was in the contract with a new one, and the old person is fully relieved of any contractual obligations that they previously had. You guys may want to snap a picture of this slide because the book does not have a good definition of novation. It does not. This is a good example explanation right here. Let me know if you got it or if you're taking it or what's going on so that I could change the slides once you're done.
Got it.
And then this is what you would highlight in the book. Novation or substitution of a new contract for an existing agreement. This new agreement may be between the same parties, or a new party may be substituted for either. This is novation of the parties. In the case of novation, the old contract no longer has any force. Okay. They improved the definition a little bit, but it's still lousy. It's better than nothing. So now we're going to go over the different ways that a contract may be discharged. So contracts can be completely performed with all their terms fully carried out, or it may be breached. That means broken if one of the parties defaults. In addition, there's various other methods in which a contract can be discharged, and they include partial performance. The parties have only partially performed their legal obligations that they promised to do in the contract. So they did not do everything the contract required of them to do. They've only partially performed. Substantial performance is when the parties perform the terms of the contract, but they did not substantially perform. They didn't do everything exactly the way. They did everything the contract required, but they didn't do it exactly the way the contract wanted them to. Or impossibility of performance, when the terms of the contract cannot be legally accomplished. Example, they're not able to get a permit to use the property for the intended purpose, or they're unable to get a certificate of occupancy due to the condition or some other legal condition cannot be met. It would be impossible for them to perform. Or by mutual agreement. Both parties mutually agree to cancel a contract. In that case, nobody would necessarily be in breach of contract. And then by operation of law, by voiding a contract as a result of fraud, a contract with a minor, expiration of a statute of limitations, or contracts being altered without all parties agreeing to those altered terms. An injunction, we highlighted in a much earlier chapter on page 73, is when a judge orders somebody to do something or to refrain from doing something. That would be an injunction. Now, if a seller defaults, what can a buyer do? And then we're going to go over, if the buyer defaults, what can the seller do? So a buyer can rescind or cancel a contract and recover their earnest money deposit, their good faith deposit. That's the money they have to put down when purchasing. A buyer can sue the seller. This is a lawsuit called a specific performance, forcing the seller to carry out the terms of the contract as agreed, forcing them to basically convey the ownership of the property to the buyer. They can't just on the closing day be like, yeah, you know what, I'm not signing, I changed my mind. You did what? I got my stuff in the moving truck. I gotta move somewhere. My lease is done. You could sue that seller, forcing them to convey the ownership of the property, forcing them to perform, to specifically perform as they agreed to in the contract. Now, as a general rule, a buyer can force a seller to sell, but a seller can't force a buyer to buy unless they're a moron. That's one stipulation. Yeah, I know. It doesn't say that in the law, unless they're a moron. But let me explain. It kind of does. I'll explain it when we get to the next section, showing what a seller can do if a buyer defaults, and you'll see what I'm talking about, okay? So just hold that in the back of your minds for a moment. Now, the buyer can also sue for compensatory damages. That means for money, moolah, to get paid in the event that the seller breaches the contract. Now let's go over what happens if the seller breaches the contracts. If the buyer breaches the contract, what can the seller do? Oh, before we do that, we have a term called liquidated damages here in between. We can also skip forward to page 217 and highlight the definition of liquidated damages, and then come back here to page 198, where we'll pick up. Let me know when you've highlighted this term and came back.
Got it.
Got it.
Got it.
Got it.
So liquidated damages is an agreement made in advance. It's just an agreement about how much money is going to be, how much money will serve as compensation in the event that the party who breached the contract, usually the buyer, in the event that they default. Now, it doesn't specify where that money's coming from, because if it did, then the seller cannot get any more than whatever money is where they specified that they're taking it from. For instance, if a liquidated damage agreement said that the buyer would forfeit their deposit money to the seller if they breached the contract, well, then the seller would not be able to get any more money than what the buyer put down. See, a liquidated damage agreement could be for more than the amount of money that they put down. They could have agreed to that. But if they also specified that the money's coming from the deposit, well, they could only collect what's in the deposit and nothing further from that. So this is why liquidated damages is simply an agreement. It's not wise to say where the money's coming from. It's just an agreement as to how much will serve as compensation. So if on exams you're asked, what are liquidated damages, and you say the earnest money deposit, that's wrong. It's an agreement about how much money will serve as compensation if one of the parties defaults. Now, if a buyer defaults, what can the seller do? if there was a liquidated damage agreement added to the contract, the book makes it sound like every contract that's a default part of that's in every contract, which it is not by default. You would have to add a liquidated damage agreement into the contract. But if there was a liquidated damage agreement in the contract, it is not a standard thing in all contracts. The seller can declare the contract forfeited if the contract stated they can. And if it was agreed to that they would be awarded compensation from the buyer as liquidated damages. The seller can rescind the contract as if it were never made. However, that would require them returning all the good faith deposit, all the deposit money to the buyer. And the seller can sue the buyer for specific performance. Remember, I told you they could only do that if the buyer's a moron. What did I mean by that? Well, that would mean that the buyer has to say, I don't want to buy the property anymore. Okay. And then the seller signs the deed over to the buyer and the buyer takes it. When does the transfer of ownership of real estate take place? Upon delivery and acceptance of the deed itself. So now the buyer is the owner. Why did you take the ownership if you didn't want the property? Now you got to pay me. You moron. You see what I'm saying? So this would require, though, the seller to sign over the ownership to the buyer before they pay them, and then they have to chase after them for the money. So that's the little nuance to that. So the seller can sue the buyer for specific performance. However, this would require them to sign the deed over to the buyer and then chase after them for the payment. The seller can sue for compensatory damages because the buyer backed out. Money, moolah, that's compensation, compensatory damages. You don't need to study these things if the seller defaults, if the buyer defaults, but we need to understand them because this is our business. We need to understand what would happen or what could possibly happen in the event of any of these things. So let's do the highlights, I guess, on page 198 about that. Now, they didn't shade this. This is the title. If the seller defaults, if the buyer defaults, you can put an underline or put it in a box like I did to try to separate them out. They're not just one big run-on list. There's the title and what could happen. Here's the title, what could happen. We wrote liquidated damages. We put a page number in there with the cross-reference and all that good stuff. So go do your highlights and let me know once you've got them done. And I'll do my highlights, enhancing these slides while you do that.
Got it.
Got it.
All right, everybody good? Everybody got it?
Yes.
All right. Now, a lot of the rest of this chapter is pretty much going to go over things that we've already gone over. It's like a recap of all the forms and disclosures that we've ever given to people that we've learned about, building up to the actual contract. Okay. And then we're going to go over some things that we could add into contracts. So when we're preparing the documents, the contracts, we don't write contracts from scratch. These contracts were already prepared by attorneys and approved by the Real Estate Commission for our use. They have blank lines on them, and we just fill in the blank lines. If we're using our contract form system, we have a digital contract form system, and that contract form system would be a way that we could keep track of them. We get it for free. It's for free. It's part of our realtor dues. It's included by New Jersey Realtors. Gives us that one benefit. And I remember I told you I got a domain name that I bought that points me to it, so I get to it a lot quicker. It's njrforms.com. That'll point you directly to the contract form system on the New Jersey Realtor website, which the actual link is like NJ Realtor or Realtors, I'm not sure, /.com/zip form. That's where my domain would point to, that NJR forms. Okay. But I often forget what the exact link is. But it's easier to remember, njrforms.com. So that's why I bought the domain, and I just pointed there makes it easier for me. Okay. You guys could use that same link. Okay. njrforms.com. It just redirects you to the New Jersey Realtors sites page. All right. So, NJ licensees can only prepare sales contracts for 1 to 4 family homes because anything else is considered commercial real estate. And we don't prepare contracts for that, only attorneys do, right? We just need to remember, don't leave any blank lines. Unless that blank line stipulates that if you leave it blank, it means something else. Commercial industrial property sales, remember, attorneys fill those out. We start the transaction by maybe us doing a non-binding term sheet or intent to purchase or lease. And then we turn that over to the attorneys, and they write up a contract based on those agreed upon terms. So contracts must indicate the business relationship the parties have with respect to the parties named in the document. On page 209, section 29 of the contract, you'll see what I mean. Here, let me actually open up a contract so I could keep referencing it to you. That may make things a little bit easier. Let's see if I got a sales contract here that's been filled out. And I do. Now, let's see what that slideshow said again. It said section 29 of the contract. So the page numbers may be a little different because the contracts change sometimes, so the line numbers may be different rather. But section 29 of the contract. So here's the opinion 26 notice. What does that tell you? What's the purpose of the opinion 26 notice that needs to be the cover page of any contract? Come on, guys. You should know this.
That's not the one
They have
that right for a lawyer.
It's your right to hire a lawyer, right? And that's the cover page. Now here's the actual contract. So what is section 29 here? It says declaration of business relationships. So you can see we have line numbers down the contract, and we also have section numbers. All right. The section numbers correspond to the table of contents here. All right. So this is the way attorneys would make adjustments to contracts during attorney review. They'll say, delete this line or this section and replace with this. That's how they make the modifications to these contracts. So we got to go to section 29 and see what they mean about business relationships. So let's scroll down a bit. Yeah, section 15. Got to get down to 29. Scroll. 22. There we go. 29. This is all section 29 here. Declaration of brokers' business relationships. You put the name of your brokerage, your name, check off how you're working on on this transaction, and then put the other agency's name and how they're working in the transaction. Check off their agency relationships, how they're working, how you're working. All right, that's what they're talking about on this slide. And then the opinion 26 notice must be the cover page of the contract, which we just saw was. That's your right to hire a lawyer. So New Jersey requires the following statement be added to the top of the first page of any sale or lease contract prepared by licensees that say that this is a legally binding contract. But what the full phrase says is this is a legally binding contract that'll become final within 3 business days. And during this period, you may choose to consult an attorney who can review or cancel the contract. Does it? Let's take a look. Let's scroll back to the first page of the contract after the opinion 26 notice. There we go. This is a legally binding contract that will become final within the 3 business days. You see how it says that? Why don't you go to that first page of the contract there, which is on page 200 in the book, and let's highlight just this part that says this is a legally binding contract. So you could reference that and remember that and see what they're talking about there. All contracts prepared by licensees must disclose agency relationships to the party named in the document, and we just saw that in that section 29. And so we'll highlight that where it says this is a legally binding contract. What the full phrase says is that it'll become final within 3 business days. During this period, you could consult with an attorney, yada, 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 yada. So how does attorney review work? Well, it works like this, and this actually is even written into the contract itself. It says this, the attorney review section, right? There's that, where's the attorney review section? Somewhere in here. Help me find it, help me find it. Where does it say attorney review? Attorney review,
35.
section 35, you see that right there? So let's go down to section 35 of the contract. There we go. 35, attorney review clause. Kind of looks similar to what we see there on our on that slide. So, but this is broken between pages here. So what we'll do is we'll just go read it from the slide here. There you go. Makes it a lot easier. So how does attorney review work? Well, after the contract is signed by both parties, we have 3 business days to get the contract to the attorneys and start the attorney review process. Otherwise, the contract becomes legally binding as it is, and nobody can make changes unless everybody agrees to those changes. So once the attorneys get it, okay, so we got that counting of time. We got 3 business days, but that could be extended by attorneys or both sides if they agree to extend that. Or maybe halt the attorney review until the happening of a certain event. Counting of time does not include legal holidays or weekends. To begin attorney review, to make modifications or cancel the contract, otherwise it becomes legally binding as it is. And then nobody can make contracts without the other side's approval. So we get the contracts over to the attorney, and both parties must receive the duplicate original of the contract. Then we start counting of time to deliver the fully executed contract to both sides. There we go. Then the contract counting of time. And then the notice of disapproval. So one of the attorneys, one of the side's attorneys will send out a notification to the other that they're in receipt of the contract for whatever the property it is. And then they'll say, we agree to we disapprove of the contract in its current format, but pending all these attached changes that we've proposed here, If you agree to them, we can conclude attorney review, and that attorney will sign off, and then there will be a signature there for the other side to sign. And if they just sign it and return it, then attorney review is concluded. Or they can make their own modifications and suggestions and then send it back. And then each side has 3 days to respond to the last side's last correspondence. That's how attorney review works. Attorney review is not necessarily 3 days. It's just that each party has 3 days to respond to the last correspondence to make sure the ball keeps rolling, you know? So once the parties have agreed and everybody's signed to all the changes, it is said that they've come to a meeting of the minds, yet again. So once both parties come to agree on all the terms of the contract and sign off of them, they're now in a legally binding contract with each other, and attorney review has been concluded. That's the way it works. And contracts also have to have a federal lead-based paint disclosure in them. Even though the disclosure statement is separate from the contract, the actual contract has something that refers to it on section 13. Let's take a look at that. So once again, let's see, section 13, yep, lead-based paint or lead hazard. Okay, so let's go to section 13 then and see what that's about. Whoop, we passed it. There we go. Section 13 starts here. Lead-based paint or other lead hazard. Was this property built prior to 1978 applicable or not applicable? If you're not sure, then leave it blank. You don't know. So give the disclosure. Still give this. If you're not sure, give the disclosure anyway, because you're not sure. And then it goes over that each, party got the lead statement, the pamphlet, and the right to an inspection. And if there is an inspection, each party shall give how many days to the other to respond in the event that they do find lead of what they're going to do, if anything. Okay, so that's basically what that is. So any property built prior to 1978, we got to give that lead paint disclosure statement. That needs to be first filled out by the seller, the owner. And then the buyers or renters are supplied with the pamphlet. They're given that statement that was first filled out by the owner and given a 10-day opportunity to conduct their own lead inspection or waive that opportunity if they want to close any sooner. All right, now contracts, we use the contract forms that are already prepared. We just fill in the blanks. Listing agreements we get in order to market those properties to begin with. Then buyer's brokerage agreements. We have transaction broker and dual agency agreements that we've gone over. And then the sales contract doesn't have any official name to it. Some people call it a sales contract. Some people call it a purchase contract. Some people call it a contract to purchase and sale. Some people call it earnest money binder agreement or many other names it may go by. There is no official name for it. Okay, so as you see here in the book, it's known as an offer to purchase, contract to purchase and sale, earnest money agreement, binder and deposit receipt, yada, yada, yada. Call it whatever the hell you want. There's no official name to the contract. It's the contract, I guess you could call it. All right. So let's just do these. Let's just copy these highlights. So we're going to move on to the next slide, which apparently will give us another explanation for this. We're just going to highlight a broker list an owner's real estate for sale at the price and conditions that are set by the owner. Who sets the asking price? The owner. So, you know what I'll even do? I'm going to underline that, the owner. By the owner. And once again, just do the highlights here. Any attempt by the seller to change the terms proposed by the buyer creates a counteroffer. Okay, we're going to have all this in one slide that we're going to read it all. So right now we're just doing the highlights for this, okay? And you're going to write in here where this highlight is, you're going to write delivery, acceptance, and signatures are not required, but recommended. It's all on page 215. So this section right here is right beneath that that graphic drawing in the middle of the page of 215. An offer is not considered accepted till a person making the offer has been notified of the other party's acceptance. So therefore, delivery, acceptance, and signatures are not required, but highly recommended. So technically speaking, because this is probably an exam question, in contract negotiations, when is an offer considered accepted? Once the other party's been notified. You don't need to have their signatures in order for it to be considered accepted. You get on the phone, you say, we got your contract. I showed it to the seller. They agreed to it. Your offer's been accepted. Then it's been accepted. Now, it's always a good idea to follow up with getting them to sign off on it and send it back to you. So now you have a fully executed copy of that contract. But technically, when is an offer considered accepted? Simply upon notification. But good luck proving that later. You know, if they change their mind and don't want to agree to that, you need some kind of proof, so you should get it in writing. But the exam answer option that would be correct would be simply upon notification. In practice, do everything in writing.
Got it.
Got it.
All right. So how does offer and acceptance work? Well, one of the essential elements of a valid contract is the meeting of the minds, where the parties to the contract are aware and in agreement of all the contractual terms to that contract. And this is done through the process of offer and acceptance. So how does it work? Well, first the seller lists their property for sale at an agreed upon price. Then a buyer makes the offer at the full listing price, or perhaps maybe another amount, which their broker then presents to the seller within 24 hours. Remember, you got to forward all offers within 24 hours. Then the seller either rejects the offer, they accept the offer, reject it, or they make another counter offer, which is basically a rejection to the offer that had been made. So at this point, the buyer's free to just walk away. They don't even need to respond to it. So what are your options if somebody rejects your offer or gives you a counter offer, which is essentially a rejection? Well, you could accept it, you could reject it, you could ignore it, or you could give another counter offer. So if the seller accepts a counter offer, the buyer can then accept it, reject it, or counter it. They could go back and forth like this until one of the parties agrees to the other's terms. And when they do, this is called the meeting of the minds. They've come to a meeting of the minds. And then the offer is accepted pending attorney review. And then in attorney review, they'll come to a meeting of the minds again after they make all the modifications and tweaks. It is still not a legally binding contract until the attorney review is concluded or 3 business days pass if not doing a review. So in contract negotiations, when is an offer considered accepted? Simply when the other party's been notified that their offer's been accepted. Now, this can be done verbally. However, it is suggested, and it's always a good practice to follow up with getting it in writing, but it's not required in order to be considered accepted, at least for exam purposes. In real life, you'd really want to follow up with getting it in writing. All right, so that's a good explanation, probably a little bit clearer and better than the one that the book has.
Here a quick question.
Yeah,
So as we are going back and forth with these offer and counter offers, is that done verbally or each time you need to have something in writing? How does it work mechanically?
I'm not gonna take verbal counter offers. Remember, everything that we do, the real estate commission says we should do it in writing.
So,
Okay, hold on a second.
counter offer
Here,
in
here,
writing.
hold on. What is a verbal offer?
In the midst of negotiation, you say, my agent calls me and says, the seller wants
All right,
X amount.
let's not get technical. In your view, in your purview, what does a verbal offer mean to you?
Is that I didn't sign on it, but I'm making it's an implied offer, I guess. I don't know.
To me, it's fishing. You're on a fishing expedition. And listen, I've learned this when I've dealt with people who just turned out to be freaking annoying. Because most people don't act like this, but when you come across somebody that does, you come to a realization that a verbal offer is a fishing expedition and it don't mean squat. How do you prove it? It doesn't mean anything. The person could be just fishing to see how much they could get away with, and I've had this happen before where somebody's made an offer. It was rejected. And maybe they made a counter offer, maybe they didn't. And the other person says, okay, I'll give another counter offer, $100 more. $100, are you for real? Because they made an offer, they did a counter offer, they're like, okay, well, I'll do another counter offer, $100 more. Like, really? You think you're gonna get it for $100 more for a counter offer? Usually when we're doing counter offers back and forth, we're talking about thousands, tens of thousands of dollars more. We're not talking about $100. You're not being realistic here. So the guy gave a counter offer verbally like this. Okay, make it $100 more. No, they're not going to accept that. Okay, make it $200 more. Make it $300 more. Make it $301 more.
I see your point.
You're on a fishing expedition. You're dealing with somebody now. At this point, you got the thought going through your head. You're an ass. So you have to. I only do it in writing. I'm like, listen, I'm not going to present a written offer, a verbal offer. Put it in writing. Your verbal offer doesn't mean squat. I can't prove it. I can't get somebody to sign off to accept it. Yeah, put it in writing. Verbal offer means nothing. Verbal offer is not an offer at all. You could be like, oh, I didn't make that. Or you could just be fishing like this guy. $100 more, $100 more, another. How about $101? I mean, get the hell out of here. You're not for real. In that case, I tell a seller, don't even reply or just reject it or counter them full price or more than full price. You want to play a game like that? Okay, we'll play. Okay. We'll make a super duper lowball offer and then we'll start inching it up $100 at a time until we see if we break you down until you find out what's acceptable to you, or you crack and just say, well, just make sure it's above a certain amount. And we're not going to do that. We're going to say, make your highest and best offer, put it in writing, I'll present it to the seller and we'll see what we get accepted. That's the way it works. If you're not putting it in writing, there's not as much effort on your behalf in there. You're not that serious about it if you're not putting it in writing. Why do you refuse to put it in writing? Because you're not serious. We're not going to take you serious.
Makes sense. Thanks, Victor.
Sure. I dealt with that before too. That was the most annoying situation. And listen, like in Indian culture, like negotiation is a way of life. Everybody negotiates. And so it's very, very common in Indian culture for people to be negotiating like that too. So you guys got to realize cultural differences too when you get involved in real estate. From different cultures, from people all around the world, different people have different ways of doing things. Some people, if you don't negotiate with them, I mean, you have to negotiate everything. Yeah. So some people like negotiating, some people don't, and when you get to negotiate like this guy did, that's just ridiculous, so, we just dismissed him as being a serious buyer to begin with, and that's the risk that you run if you start doing stuff like that, okay. So highlight this on page 215 about the earnest money deposit. It's customary, but not essential for a purchaser to provide a cash deposit, a check, when making an offer to purchase real estate. This cash deposit is commonly referred to as an earnest money or good faith deposit. And then put a little asterisk down here, and we'll have an explanation of all this instead of reading it here. We'll just read it on the next slide. I got a breakdown of this stuff. Okay, it's the bottom of page 215. Everybody's awake, right?
Yeah, we're here.
Yep.
All right. Yeah. I notice when your cameras are off, you're a lot more quiet. It makes me wonder if you're watching cartoons or something. I don't know. Look, you got to let me know when you guys get the highlights and such so that we could keep continuing moving on. So I'm not guessing and just hoping I'm giving you enough time to do this, because you could have gotten the highlights a lot quicker. And instead we're dilly-dallying and, we got a lot to get through. So I need to make sure that we could keep moving along as swiftly as possible.
Got it.
Okay.
Got it.
I don't want to rush you. I want to make sure you have enough time, but I don't want to sit there waiting in the meantime needlessly. All right. Okay. And continue highlighting this now on page 216 as well. At the top of the page there. And I want you to write this in at the top of the page. If a liquidated damage agreement was added to the contract, it's not standard in all contracts.
Done.
Got it.
So now let's read over. I got everything for the last couple of slides right here in this one slide, which would not be a bad thing to study from. So let's go over that now, what we highlighted and wrote in on the last couple of slides. So sometimes referred to as a good faith deposit, it's money it's money the buyer puts down when they're making their offer. The purpose of the good faith deposit is to show that the buyer's operating in good faith and they plan to complete the transaction if the seller accepts it. So an offer is still valid even if the buyer doesn't make any good faith deposit whatsoever. but it's customarily at least $1,000. So you guys should get in the habit of asking your clients to make a minimum of $1,000 good faith deposit when making an offer, especially if you're in a competitive market where there's multiple offer deals that are expected. You should probably make the highest good faith deposit that you possibly can. It shows the buyer that you've got the money and that your intention is to go through with this purchase and you're a serious buyer. So the buyer, by putting down that good faith deposit, the buyer's asking the seller to take their property off the market. So you really want them to make a large enough deposit to show that they're serious with their intentions to go through with the transaction. And if the seller rejects the offer, the earnest money deposit is immediately returned to that would-be buyer. If the offer is accepted, that money would then be credited towards the buyer's purchase, but it's held in their broker's escrow account or their attorney's escrow account. Brokers must deposit any money that is given to us into our escrow account within 5 business days. Remember, after we do our bookkeeping in the escrow accounts, it's within 5 days of the money being given to us, not within 5 days of the offer being accepted, though. And any cash deposit of $10,000 or more, we need to report to the IRS. I don't suggest accepting cash deposits because of that and many other reasons, though, which we've gone over in an earlier chapter. And the broker is required to keep escrow deposits records on file for 6 years, just like everything, 6 years. So what is a meeting of the minds? Not the first time that we saw this slide. It's when all the parties are in agreement on all the terms and details of the contracts. Once again, the school exam definition for a meeting of the minds is when the parties are in agreement on price, down payment, and financing method. How are you coming up with the rest of the funds? A kickback is giving anything of value to an unlicensed person. An example of that would be giving a friend money or a gift in exchange for a lead, including rebates to a seller, because sellers cannot get rebates legally in New Jersey. Buyers, however, can. If they're a buyer of a primary residence, we can give buyers rebates. However, you need to follow the rules and regulations pertaining to buyers' rebates. You have to have a written agreement in place at the time the relationship begins working with them. And you have to stipulate how much that rebate is going to be, whether a dollar amount or a percentage or what have you. You got to let all parties in the transaction be aware that you're offering a rebate. And you got to let the buyer know that they should consult with a tax professional with regards to receiving that rebate, because depending on how much it is, they may have to pay taxes on it. So closing gifts to buyers should also be limited to a smaller amount, $25 or so. I mean, if you do make it larger, just try to make it in a way that it cannot be in any way construed as a kickback, okay? So let's go over the essential element or parts of a contract, things that are required to be in a contract. So contracts must be in writing, according to the statute of frauds, right, for purchases. You have to have competent parties. There has to be an agreement to buy and to sell. There has to be an adequate legal description of the property. The consideration must be expressed. There's 3 legal forms of consideration: legal tender, exchange of value, and love and affection if it's a gift. You have to have a grantor's agreement to convey the property. That's the seller. And a place and time of closing should be stipulated in the contract. And signatures with all the parties, by all the parties who are purchasing and selling, with their all initials on the bottom of every single page of the contract, so that nobody can swap out one single page and replace some of the terms, you know? You don't just sign the last page. So these items are often included in the contract as well, but they're not required to be in every contract, because sometimes some of these terms may not apply to your situation. So therefore, they're not required. Like any encumbrances to which a deed could be subject to, deed restrictions can be placed in the contracts. However, what if there are no deed restrictions and there's nothing to place in there? Earnest money deposit. Well, contract is still good even if there is no earnest money deposit, that good faith deposit. The mortgage financing the buyer plans to obtain, well, they could be buying cash. Possession by the buyer, when they plan to possess it, when is it available for possession by the buyer? Maybe we don't know yet. Title evidence, what kind of title evidence are they going to provide? Prorations and adjustments, those are those final adjustments in the closing figures. We don't put that in contracts. Destruction of the premises. We usually have something in our contracts pertaining to this, but it's not required to be in there. What happens in the event that the house has a fire while you're under contract and it burns down or something, default by either party. What if either party defaults? What would be the consequence? You don't have to write that in a contract, but our contracts usually state these things. A right to a final walkthrough. Which we should do on the day of closing. We do walkthroughs, but we usually don't write it in a contract. And contingencies would be listed in a contract. It's important that if you do have any contingencies that they be added to a contract, but you can be submitting an offer that's totally contingency free. So what is a contingency? It's a happening in which the contract is dependent upon. Or you can look at it another way. It's a way for the buyer to get out of the contract. So you should submit contracts as contingency free as possible. Now, you could have family members that are helping out with money towards purchasing a house. And if that's the case, they're not going to lend that money or give that money to their relative unless they see the house first. If that's the situation, it's up to us to make sure that that's a thing. And if it is, we need to get them through that house before we ever write the contract. Because if you don't, now you're writing a contract and you got to put down a bunch of names of people, depending on how many people are lending or giving the money to their relative. And in some cultures, this is actually very common where family, extended family, they help with the funds to purchase a property. And if there's a lot of people involved, you can be writing down a lot of names on a contract. And just imagine the buyer from the seller from the seller's view now, that the seller sees this contract, this offer that comes in on their property, right? And when they see this offer coming in that has the contract contingent upon, and it lists like 20 names on it. And they're like, what the hell? This contract, you're making an offer, but that offer's contingent upon all of these people giving an approval for the purchase? What the hell is that? So basically any of those people can say no, and then you could back out of the contract at any time and not be in breach. From a seller's point of view, I'd be like, screw that. That's a weak contract. All right. So it is better to get those people through the house first before you ever write the contract. Now, anybody can help with money. We could have family members that are helping you buy a house. And anybody can do this. But I am going to tell you guys, by far, this is common in Indian cultures. I see it by far a lot more with Indian people, where you're seeing family members that are kicking in money, helping their relatives purchase a house. I rarely see it among the other demographics, but it can happen. You could have a relative that helps you with money for down payment or purchasing a house. But by far, it's way more common in Indian culture. I see it a lot. That doesn't mean that every Indian family is doing this, but I do see it a lot. Okay, so you just got to be aware that this is a question you should probably ask people. If you're purchasing this house and you're working with a buyer, you got to ask them, how are you getting, how are you purchasing? Are you buying with cash or are you getting a loan? If you're getting the cash, are relatives helping you with that, or do you have the money? We need to know if we need to get anybody's approval, anybody else's approval in order for you to go through with this purchase. If that's the case, let's stop right here before we finish writing the contract and let's get those family members into the house. Because I've had situations before where I've had 3 carloads of family members that we had to take over to the house and get them approved, because I was like, wow, I would have had to written all these people's names down on the contract as the contract subject to the approval of 3 carloads of people's names, plus 2 people who are driving down from Canada. So even after I got 3 carloads of people in there, I had 2 people that we had to wait for them to drive down from Canada. As soon as they got down, I took them to the house, let them check it out. They gave their thumbs up of approval. I got on the phone with the attorney. I said, they're cool with it. You could remove them as a contingency. They removed them as a contingency, and then we got it through. So you should remove contingencies from contracts as soon as possible. And then we went out to lunch. And signatures of the witnesses are not required, although we usually sign contracts next to the buyers and sellers, our clients there. But the contract is still valid even if we don't. Here's some other common contingencies we see in contracts. FHA and VA loans, they have a special contingency clause that must be added into contracts by law if the financing is coming through FHA or VA loans. If it's subject to an engineer's report. If there's we're going to add an escape clause. Escape clause, also known as a kick-out or knockout clause. This is something that we would have a buyer place in the contract when they have another house they need to sell first. We say that the sale of the house is contingent upon the sale of their current home, and we make that offer contingent upon that. But you should elaborate on that a little bit more. Let the seller know, well, is the buyer's home even on the market yet? Is it under contract? When is the anticipated closing date? Give them a little more detail, Otherwise, it's like, okay, so you want to make an offer contingent on the sale of your home, and your home's not even on the market yet? No, Now, if the seller does accept that offer, contingent on the sale of the buyer's current home, we could have the seller add an escape clause, also known as a kick-out or knockout clause, into the contract that says, okay, we're going to accept your offer. However, we're going to continue marketing the property. And in the event that we get another buyer that makes an offer that's acceptable to the seller, we're going to come back to you and give you the first right of refusal to be able to see if you're ready to remove that contingency that the purchase is contingent on the sale of your home yet. And if it's not, we have the right to escape from this contract without penalty. We could exit this contract with you and not be in breach of contract so that we could accept the other offer. That's what an escape clause is. So who does an escape clause, also known as a kick-out or knockout clause, protect?
Seller?
The seller. The seller. Yep. So liquidated damages, we went over that already. Short sales, we're going to go over what a short sale is, subject to family member approvals or subject to zoning or building permit approvals. But a short sale could be subject to a short sale. You would write in there that this purchase is subject to the not just the seller's approval, acceptance of the offer, but the seller's lender or a bank or other third party who this contract may be dependent upon. or subject to zoning or building permits or approvals. If you only want to go through with the purchase, if you could do something to the house or to the property. Yeah, that's more common in commercial real estate, but you could add something in there for residential, especially if it's maybe mixed use. All right, so on page 217, let's write this in. Next to contingencies, let's write subject to, because usually contingencies are added to contracts with the word subject to in there. The purchase is subject to this, that, or the other thing, okay? When you see that term subject to, it usually has to deal with that. Oh. All right. Mhm.
Got it.
Got it.
Okay. So on the side here, I just put a little bracket around this. I wrote escape, kick out, or knockout clause protects the seller. You guys got that too?
Yeah.
Yep.
Yes.
Yep.
Okie doke. So contingency is a happening in which the contract is subject to, and if the terms are not met, they could get out of the contract without being in breach of contract. Agents should address and remove contingencies as soon as possible. That's what ASAP means. Now, appraisal. The contract can be contingent upon the appraisal. And that's what the special contingency clause that's required for FHA and VA loans is. It basically says that this purchase is contingent upon the property appraising for the purchase price, and if it does not, then the buyer can get out of the contract without penalty. That's what the special contingency clause that all FHA and VA loans require be added into contracts. Now it's not even a clause that we put in, it's actually a separate addendum that they've created that we have to add into the contracts when the buyer is purchasing using an FHA or VA loan. VA loans are those for veterans, and FHA loans, well, those are those loans that are insured by the FHA. Neither the FHA or VA actually lends money. The VA guarantees up to 25% of the loan amounts, and the FHA insures the loan. So basically, if you go to your local lender to try to get a bank loan, the FHA says to the lender, hey, listen, if the borrower meets our lending criteria that we spelled out here, and the property they're purchasing meets their lending criteria, give them your money, lend them your money, and we will insure you against loss in the event that they default in making their payments on the loan. We'll make sure you don't lose a penny. That's what the FHA insures. The VA says we'll guarantee 25% of the payment in the event that the veteran defaults in the loan. So because it's the government guaranteeing 25%, it's as if they put down 25%. So therefore, no, these could be 100% financing loans. There's without any kinds of insurance required on the loan, like PMI, private mortgage insurance, etc. Contingency could be based on a home inspection. Make sure that it is by a licensed home inspector. Remember, I gave you that link there where you could search to make sure their license is active. Contingent upon them getting a specific mortgage loan. or approval by family members who are helping out with the money, or contingent upon purchase is subject to the sale of the buyer's current home. And then in that case, we would make sure that the seller, if we're representing the seller, we would insist on adding an escape, kick out, or knockout clause to the contract if they're going to accept an offer subject to the sale of a buyer's current home, so that we can look out for our sellers there. Or expiration of the buyer's lease, subject to the permit for the property, or a building permit for construction. This is often done with the commercial real estate too. Often with commercial real estate or large residential projects, which are considered commercial, where you're doing entire subdivisions. Often these developers may put offers in to purchase acreage and acreage and acreage of land because they plan on building a big subdivision. All right. But they don't actually go through with the purchase until they get all of their plans approved to do the construction. So they make a purchase offer that is subject to getting all the environmental and city approvals and this and that and the other thing. And once they get all those approvals, then they will go through with the purchase. So often they could spend thousands or hundreds of thousands of dollars in engineering reports and seeking approvals and this, that, and the other thing before they ever go through with the purchase of the property. Because the property purchase is subject to them of getting these things first. Or let's see, or a building permit for construction, or subject to third-party approval, like a short sale, bankruptcy, or estate sale, where maybe the sale could be contingent upon third parties, like banks or lenders' approvals. So liquidated damage agreement, we already got this highlighted. That's just an agreement that will serve as compensation if one of the parties breaches the contract. And New Jersey has a plain language requirement for their contracts that basically state that all contracts have to use common words that are used in the everyday English language that don't have a separate legalese meaning to them. This was reduced to basically a blurb of 2 lines now in the book. It used to be almost a full page. But they reduced it to a little blurb because it practically applies to no properties. Because it only applies to properties valued under $50,000, according to the law. And good luck finding a property under 50 grand in New Jersey these days. They're out there, but probably not an area you want to live in. All right, and remember, what is a right of rescission? This slide we've seen in a lot of different chapters with all our different rights of rescission. It's a right to cancel a contract within a given period. And for all the sales contracts, they all deal with new construction, except for the last one here, which is the 3-day attorney review, which deals with resale as well as new construction. There's that 3-day attorney review period right of rescission. You could back out of a contract and cancel it at any time while you're still in attorney review. The 7-day right of rescission for new construction for out-of-state properties, for large subdivisions, or maybe those timeshares. You got a 7-day right of rescission for new construction for large in-state subdivisions or those with common area elements. 5-day right of rescission for new construction for the discovery of off-site conditions not on the property. And then for mortgage financing, for the loans, there's a 3-day right of rescission for refinancing property you already own. And there's no right of rescission whatsoever for purchase money mortgages. What is a purchase money mortgage? Read it backwards. It's money, mortgage money to purchase. It's any loan used to buy real estate. Once you sign on the dotted line, you close on the deal, you bought it. You're married to it. You're not backing out of that loan. That money's been distributed to pay off the seller's existing loan. Seller gets proceeds, realtors get commissions. That money's been distributed so many different ways, you can't claw it all back. So there's no right of rescission on purchase money mortgages. All right. So let's do the highlights on that stuff now.
Got it.
Awesome. Woo. All right, so next up, option agreements, they got to be prepared by attorneys. They are unilateral contracts, if we recall. What is a unilateral contract? The one-sided agreement or promise. One party is required to do something and the other has an option to act or not. So let's highlight option agreements. And then in New Jersey, they should be prepared by attorneys. And then draw that arrow there. So option agreements should be prepared by attorneys. All right. Land contracts, we should already have this highlighted, right? Oh, wait. No, we didn't do that yet. Let's just highlight this and then we'll go to the next slide. We'll get the explanations on it. Do these highlights, underlines, and then these highlights, and then we'll go to the next slide and then we'll go over the explanation of a land contract. No, we did not go over this yet. So we're about to.
Got it.
So land contract, okay, you may want to snap a picture of this slide because it's a better explanation than this slide, which is what's in the book, which you just highlighted. So I do a little clearer of an explanation, I believe. I don't know, I haven't read the book in a while. Let's see, maybe they made some changes and clarified it. Let's take a look. Yeah, it explains, but it's not that great of a, it's not that clear. All right, so land contracts should not be confused with a ground lease, which we're going to learn about in the next chapter. Land contracts are also known as installment sales contracts, where the buyer makes payments in installments and then waits for the deed. It's kind of like a lease to own. That's a land contract. But a land contract is a form of seller financing. So the owner does not turn over the deed to the buyer until the buyer has paid off the full amount owed, which could be the full purchase price or some other agreed upon amount. Once they've reached that threshold, then they'll sign over the deed to the buyer. And until the buyer pays off the full amount, they do not get ownership of the property. However, they do have a financial interest in the property because they've been making periodic payments, building up equity towards the ownership. So therefore, they have something called equitable title. Title means ownership. Equity is a built-in value of sorts. So even though they don't own the real estate, they do have a financial interest in that property towards the ownership of it. So if the buyer fails to continue making payments, the seller does not need to go through the hassle of foreclosure because the buyer doesn't own the property. So it's easier to get them out than a renter, harder to get them out than easier to get them out than through foreclosure, harder to get them out than a renter. Now, why would anybody do this? Maybe the seller, it's a way for the seller to sell the property. And they could also earn some money off of the charging them interest for the financing. The buyer may not be able to get a loan elsewhere or through other means. So they do it through a land contract. Now, equity is the difference between the market value of a property and what is owed on that property. So the difference between what is outstanding on the loan and the market value of the property is how you determine equity. And equity is commonly built in three different ways. Well, through the market fluctuations, sometimes property values just go up and down. And if the property value goes up, you build equity. So you bought it at this value and now the market value went up, you got that much equity, okay? Or you bought it here and you do improvements on the home, increasing the value, building equity. Or you pay down the debt, you pay down the loan, increasing the equity. It's the difference between what's owed on the property and the market value. Any questions?
Yeah,
Victor,
can you,
land?
Ooh.
Right.
Shoot.
All right, go ahead.
Yeah, Victor, so land contract I thought would mean empty land. You're saying it could be land and a building on it, meaning a residential unit.
Yeah, it's owner financing. Sometimes it could be for land, but there could be a structure on it as well. Look, if you're just buying raw land, you may have difficulty obtaining financing just to buy land. Usually banks will lend you money to build a structure, but to just buy raw land, it's a little risky for banks. It's harder to sell just raw land, so they don't want to get really involved in lending money for that. So a land contract, that seller financing, sometimes is a good workaround. So, but it's not necessarily a contract just to buy land. It's seller financing.
Thank you.
Somebody else had a question?
Yeah, I was gonna say, are there gonna be any math questions on like how to equal the equity?
No. No math problems on equity. But we will have math problems where you get into a lot of the math problems come through the chapter 16 and chapter 14. And then I think we got another math problem in chapter 17 and another one in 21 that we're going to do.
Got it.
So you remember earlier on, we had a couple math problems dealing with commissions and lot sizes and stuff. And now we're going to have some math problems on some determining value and mortgages and calculating mortgage payments and stuff like that. So the financing chapters will have some math. Why, you're so excited? You're excited about math?
Yeah.
A lot of times people, when I say math, they start to profusely sweat. All right. No panic attacks, please. All right, so yeah, I prepared some slides for you here. Unfortunately, this tiny URL I made about that free tax record system is no longer in play because this is that one that we looked at the other day from Monmouth County, where now they made it so that you could only search Monmouth County. Monmouth County sucks. Why did they do that? Why did they shut that off? I'm going to see if I could do some programming and playing around with this, and maybe I could manipulate it so that I could have access to all those counties again. Because previously it was for all the counties, and now it is only for Monmouth. I wonder why they did that. But to give you access to all of these county tax boards, you can go to these websites. These are all the ones that they used to have interactive involved in that search. Wonder why they took it out. Oh no, that's going to be in a CGI bin, so I'm not going to be able to do that because I don't have the access to that. So. All right, whatever. I'll see if I can find another tax record search system. I already got a note about it. All right, but NJR Forms is that shortcut that I made for you that'll take you to the New Jersey contract form system. Takes you here, njrealtor.com/zipform. That's the contract form system that we can log into, and we could create contracts from. We could create profiles for our client. We could go back, update contracts. We could create digital contracts. Well, it looks like they made some revisions in 2024 to some of the contracts. Let's see, what are the revisions they made? New Jersey law on flood risk notifications, which will take place on March 20th, 2024, requires sellers of real property to make certain disclosures concerning flood history and potential flood risk. Okay. Something new. Revision of Form 125 for leases. Potential flood risks for the leases as well. I guess because we've seen some of these extreme storms like 2 years ago that flooded areas that normally don't even flood. They got hit with floods and backing up and stuff, right? So, and it's all about flood stuff. So you can see though, this contract form system, they keep updating the contracts for us with like updated updates and revisions to the contracts themselves. So this is why a lot of brokers just use them instead of relying on their own contracts, because the New Jersey attorneys, New Jersey realtors attorneys, they update these contracts. And then print out a copy of the MLS, printout of that listing that you want to make a contract for, or have it open in another screen so you could copy and paste information into it. Or you could pay for an upgraded service of that zip form where it'll pull the information from the MLSs and the tax records for you, but then you'll have to pay money for that additional add-on services and abilities to this standard contract form system. We're going to need another window open to open up the Real Estate Commission's website that we could search, because we have to add to contracts now. The brokerage license number, the agent's license numbers and information. And so I have a couple tiny I got a tiny URL here for the that'll point you to the Real Estate Commission's website. This tinyurl.com/NJRE license search. Or I just bought a domain name that points us to that. That's NJRE reclicense.com or njrealestatelicensesearch.com. In any event, it takes you, they all take you to the same place. They take you to this much longer link that has dashes and underscores and is case sensitive. So I'm not showing it to you. has dashes and underscores and is case sensitive. This is the link that it actually takes you to, where you could search the license numbers of agents to see, get their, you could search their names, get their license numbers, get their brokerage license numbers, get their brokerage addresses and contact information. And then you could add that to the contracts because that's required. Okay, and as you can see, this link that I have here, NJ Rec License, where does that take you? To the same place. As you can see here, NJ Rec License, it just forwards you to the same place. And I also have this link, NJ Real Estate License Search, which forwards you to the same place. As you can see up here, NJ Real Estate License Search. So these are just domain names that I buy, and I just point them to certain areas because it makes it easier to find them and remember those links than the long links that the Real Estate Commission actually has here. That www, not dot, but dash, you know, I mean, these are long, confusing links to remember. So you could either make shortcuts to them, or you could just remember, you know, NJ Rec License or NJ Real Estate License Search.com. You know, it takes you to the same place. So these are just shortcuts that I make up for your convenience, as well as for the getting you to this njrealtor.com/zip form. You could just go to njrforms.com and it takes you to the same place. Okay. See how I did that? Makes it a lot easier. We're going to need a copy of the buyer's pre-qualification or pre-approval letter when submitting an offer, or if they're buying cash, proof of funds letter from the buyer's bank. We're going to need that lead paint addendum filled out and signed by the buyer, which was already pre-filled out by the seller, if that property was built prior to 1978. As well as a copy of the seller property condition disclosure. We should obtain that, review it with our buyer client, and have them sign that as well and submit that in with the offer. And buyers and sellers attorneys information, we should gather that because in the event that the offer is accepted, we're going to need to send it off to attorneys to get it started within 3 business days. And then a mortgage commitment letter, which we're going to write in the contract a date, 30 calendar days from the date of the contract or the completion of attorney review. That's when the buyer needs to produce the mortgage commitment letter to the seller. Now, in order to get a mortgage commitment letter, they need to complete the loan application, provide their bank statements, pay stubs, tax returns, all kinds of stuff like that, anything else the bank may want of them. It goes to the lender's underwriter, who reviews all this information, determines the risk, and sees if they're going to give the loan or not. And when they decide that they're going to, they issue a mortgage commitment letter committing to give the loan. That's what a commitment letter is. And then we're going to write a closing date on there, 60 calendar days from the date of the contract. If it lands on a weekend, move it forward or back so it's not on the weekend because you're not going to have any closings then, or on a holiday. And here's a little tip. If it ends at the beginning of a month, push it forward a couple of days so it ends at the end of the month. Lenders will tend to push and make a priority to close these transactions to get all their month-end numbers. Never leave a blank line on a contract unless leaving a blank line means something, which you'll see what I mean on contracts. They actually say if the blank line is left blank, then it means that 7 days or 3 days, or it means it has a meaning to it already. And the contract will say that if this line is left blank, then it means this, okay? Contracts must state the amount of down payment the buyer's making, if they're making any. Remember, it's customary to make a minimum $1,000 good faith deposit, but a contract is still valid even if none is made, right? You need to know that for exam. But you know what? If you're going to make an offer on one of my listings, we ain't accepting it because I'm going to whisper sweet things into my client's ear, and I'm going to be like, don't accept an offer without at least a $1,000 good faith deposit, because this clown is probably making offers on 5 other properties throwing all these offers at the wall, seeing what sticks, and then they're going to accept maybe one of them who gets accepted, and then the other ones, they're just not even going to reply to you anymore. So don't get involved with them.
I have a question.
Shoot.
So based on that, and previously you was mentioning that when you going to buy a property, right? And then the seller said that they're not going to buy the property, that they changed their mind, something happened. So that is the money that the seller can keep if you break the contract, right?
If you wrote that in the contract.
You wrote that in the contract, that's right?
Yeah.
Okay.
Otherwise, if you don't write that in the contract, then who gets the money? Well, if the deal falls apart, the money should go back to the buyer. However, if the other side doesn't agree to it, they want to make a claim on that money. Well, unless both parties agree to where that money is going, that money's sitting where right now? In the broker's escrow account?
Okay.
The broker cannot release those funds if both parties don't agree who's going to get it, where it's going to get released to.
Okay. Oh no, because something like that happened to me when I moved from I live in Florida for a year. I moved there for work. So then when I was buying a house over there, and like 2 weeks before signing the contract to purchase the property, I have an offer to go back to New York. So and then I had to cancel my buying over there to come back here. So and we lost money because of that.
Why'd you come back here? You like the cold weather?
Oh no, we have a good offer.
Okay.
But yeah.
All right. Yeah, if they try to hold on to the funds, they can't hold on to the funds. But if they don't agree, if the other side doesn't agree to release the funds, then we as the brokers who are holding the funds, we got to follow escrow rules. And basically, we can't release those funds unless the other party agrees that it's okay, so that so we know that they're not going to try making a claim against it. But they have to be making a legitimate claim against it. Sometimes they try making illegitimate claims, just hoping that the buyer will agree to give up something just so they could get some of their money back, because you're going to have to then spend money on attorneys to go to court to try to fight to get your money back and all this. But there's really rules that other attorneys are acting unethically then if they're doing that. So it should be fought. But I've come across lazy attorneys who would not fight it. And then they said, you got to hire an attorney to now litigate this in court. And it's like, well, then what good are you? I'm never going to use you with a client again. You're holding on to their escrow money. You're supposed to be representing them in the real estate matter. This person's trying to screw them out of getting their deposit money back when a deal fell apart, and it's not their fault. They should get all their money back. If they're trying to make a claim like this, trying to screw them over when they don't have a legitimate claim, you should be protecting them on that and representing them on that. It's not that hard to do. It's just writing a couple of letters. But some attorneys, they're just freaking lazy. So I've come across an attorney like that, this lady, and I told her, I'm never giving you another client again. I was like, you're a horrible attorney. You won't. So basically, you've got all these transactions, all these deals. You like the easy ones that all you do is just the easy closings. And then if anything ever comes up, you don't want to send out a letter or two or argue or litigate this. Like, damn, you're lazy. I'm never dealing with you again, because you're not actually looking out for the client's best interest. You're writing just a couple of letters here, but you won't do it to protect them, to get their money back. And that ended up being a bit of a nightmare. My client did lose a little bit of money out of it because they had to hire another attorney in order to represent him in that. And that person ended up being a useless piece of crap too. So, yeah. Home buying experiences, if you don't get the right representation, can be a bit of a nightmare sometimes. But we as the real estate brokers, we can't release those funds to anybody unless both parties agree to release those funds. Otherwise, the only person who can make a decision of who we should give the money to would be a court. If we can't give them, if parties can't agree who to give the money to, then we could only give the money to a court, and then a judge will decide who gets the money. All right, so contracts must state the amount of down payment, customary $1,000, but if no down payment, contract is still valid technically. Mortgage down payment, how much money should a buyer put down? How much money are they required to put down? Well, it depends on the loan they're getting. Your typical conventional loan could require 20% or more, sometimes less. I've had conventional loans that only required 3% down payment before. FHA loan has a minimum down payment requirement of 3.5%. It used to be 3. Then President Obama raised it to 3.5. And then when he came up for after his reelection, he raised it back up to 3.5 again. Presidents sometimes play with things within their within their control to try to manipulate markets a little bit, because then they could say, "See, I did that." And then when the election is done, then they go back to their own ways. You know, one example of this that you could verify is you could look it up. When President Obama first became president, before then, FHA only required 3% down payment to get a loan. And then he became president, he jacked it up to 3.5%. Came his year for re-election, he lowered it back down to 3%. Because more people then could afford to run out, buy a home, and put down only 3%. That 0.5% can make a difference. So then you see the increase, the sudden increase in home buying. Home buying is a good indication of where the markets are headed, that they're getting better. You know, and then after his re-election, he raised it back up to 3.5%. Yeah, it's so manipulative. What politics is such a dirty game. You know, it doesn't matter which party it is, it's dirty game. You know, you got crooked people on all sides there. Now, the VA, that's the Veterans Administration, no down payments required. This is 100% financing. The VA will guarantee 25% of the loan to the veteran. So loans to veterans are often 100% financing. However, the local lender may sometimes require small down payment. If they do, though, I would say get another lender. Concession. What is a concession? Think about elections for a second. When one person knows that they've lost the election, they usually give a concession speech, right? Conceding to the other party. That means that they're giving up. They're agreeing to give up that they've lost, right? So a concession is when somebody gives something up. So in real estate, a concession, a seller's concession, is when a seller gives up money to the buyer that they could use for their closing costs, to help them out with their closing costs to purchase the seller's home, or to help with money for down payment or repairs. All right, so there is a maximum seller concession that is allowed by law. For FHA and VA loans, that is 6% of the loan amount, not the purchase price, but the loan amount. And conventional loans, it's 3%. And typical closing costs that are guesstimated to be around 2 to 3% of the purchase price of a home. Those are your typical closing costs. So a seller's concession, how do we ask for one on a contract? Well, you'd probably write something along these lines. Buyers requesting a seller's concession of up to 3% towards the buyer's closing cost and prepaids. This is a concession and not a loan. Prepaids are basically prepaid points or interest on a buyer's loan. Where's that sales contract? Here we go. Where do we write these things in? All the way at the end of the contract. If we go all the way to the end of the contract, the last page of the contract, you see it says continued additional contractual provisions, if any. Okay, so here's the near the end of the contract. It says additional contractual provisions. Here's where you would write things in. All right. And then the next page, there's more room to write stuff in, and then there's the signatures for the buyers and sellers, okay? So this is the area where you would write in all of these contingencies. If it's a short sale, you would write in, this is a short sale, purchase price and approval and commission subject to third-party approval. And only if the seller specifies that they're not going to be taking care of the inspections, you would write in there, buyers responsible for obtaining CO and fire certificates. CO is the certificate of occupancy inspection. That's required. It's a city inspection. It's required before you can close, as well as the fire inspection, if the municipality requires them. Most of them do, but not all. And maybe the inspection, maybe the sale is contingent on the sale of the buyer's current home. If that's the case, we'd write purchase subject to the buyer's current purchase subject to the sale of the buyer's current home at 666 Mockingbird Lane, Woodbridge, New Jersey, which is currently under contract with an anticipated closing date of, and you put down a date. So we're basically also not just saying it's contingent on the sale of the buyer's current home. We're also giving the address of it. We're saying that it's currently under contract and it has an anticipated closing date. So we're giving more detail, trying to make sure our offer will get accepted. And then approvals. So if purchase is subject to the buyer's relatives, like I said, try to get the relatives through the house first. But if that's not possible to get them all through, then you need to write down that this purchase is subject to, and then write down those relatives' names that they're viewing the home and approving the purchase. They will be contributing money towards the purchase. Just spell it out in plain English like that. You don't need to write it in legalese, You could just write down these contingencies in plain English. Just choose your words wisely, because they're going to be interpreted by attorneys. Right, so you would write that down as your contingency. And then that's it. That's it for this chapter. And that's it about the contract. So that was a long chapter we got through. Chapter 12 will be another long one when we get to that next. But let's do the key terms to review, and then we'll break for lunch. There are 2 key terms to review for chapter 11. Let's start off with key terms 1. Are you ready?
Sure. Yes.
Yes.
Contract that's been fulfilled or one that has been signed, depending on the contract.
E.
Executed.
An executed contract, 12 is A. A buyer's deposit with the purchase contract.
Earnest money.
9 is B, earnest money. Contract with a promise by each party. Both parties are required to do something.
Bilateral contract.
2 is C, bilateral contract. A contract set down in so many words.
Express contract.
14 is D, it's an express contract. A transfer of interest in a contract to a third party.
Assignment.
1 is E, assignment. Those legally qualified to enter into contracts.
Competent party.
Competent party.
4 is F, competent parties. Protection for seller when the buyer has another house to sell.
Escape clause.
Escape clause, also known as a kick-out or knockout clause. 11 is G. Something of value given in exchange.
Counteroffer.
Counteroffer. Consideration.
Consideration. 5 is H. Now, what are the 3 legal forms of consideration? Anybody remember?
Legal tender, love and affection. No, I don't remember the third one.
And exchange of something of value. I'll give you this in exchange for that.
Okay, that's right. Okay.
A violation of a contract.
Breach of contract.
Breach of
Breach.
contract.
3 is I. Correct. Interest acquired by a buyer with a land contract. What do we call that? Interest acquired by a buyer with a land contract.
Equitable title.
Equitable title.
Equitable title, 10 is J. A contract that has not yet been performed.
Executory contract.
Executory contract.
13 is K, executory contracts. Offer returned to offeror with changes by offeree.
Counter offer.
Counter offer.
Is L, a counter offer. A contract not put into words, but shown by one's actions.
Implied contract.
An implied contract, 15 is M. Certain happening on which a contract depends.
Contingency.
That would be a contingency, 6 is N. An agreement between two parties to perform some legal act.
Contract.
Contract.
7 is O, it's a contract. An agreement under which a buyer pays in installments and they wait for speed.
Land contract.
16 is P, the land contract. Okay, key terms 2. Return to the status quo. That means returning to the way you began.
Rescission.
Rescission, 6 is A, yeah. You made an offer on the property, but then you canceled it, you rescind it, you return to the way you began with no contract. 6 is A. It's kind of a weird definition the way they put it though. 6 is A. Another name for an option contract.
Unilateral contract.
12 is B, a unilateral contract. 12 is B. Law requiring certain contracts be in writing.
Parole evidence rule. No.
That's those fraud.
Statute of frauds, 8 is C. A contract that is binding, but only one party can disaffirm it.
I love a contract.
Voidable.
Voidable, it's a voidable contract. 15 is D, like a contract with a minor. The minor can void the contract, but the adult cannot. 15 is D. A sum agreed on to serve as damages in case of future default.
Liquidated damages.
Liquidated damages, 1 is E. The process of reaching a meeting of the minds is also known as
Offer and acceptance.
offer and acceptance. 3 is F. Substitution of a new contract for an existing one. Actually, that's worded backwards. It should be substituting an existing contract with a new one.
Valid contract.
What do we call when you replace an existing contract with a new one? Or you replace
Novation.
first
Novation.
the contract? Yeah, it's novation. You're novating the contract. 2 is G. Contract that meets all legal requirements. By the way, that novation you'll always see on exam. A contract that meets all legal requirements.
Valid contract.
It's valid. 13 is H. Time within which one is allowed to assert their legal rights.
Time of the essence.
Time is the present.
Statute of limitations.
It's a statute of limitations. 9 is I. A court action usually asking that the seller be forced to sell as agreed.
That's the parole evidence rule.
A specific performance.
Specific performance. 7 is J. A convention that written contracts override spoken promises.
Parole evidence rule.
That's the parole evidence rule. 5 is K. A contract that does not meet all legal requirements.
Void contract.
Void
It
contract.
is void. 14 is L. Seemingly valid contract, but neither party can sue to force performance.
Unenforceable contract.
Enforceable contract.
11 is M. Contract binding one party, the other party is free to act or not.
Option.
They have option. 4 is N. And the contract clause requiring punctual performance.
Time is
Time
of
is of the essence.
Time is of the essence, meaning it's very important. 10 is O. And that concludes chapter 11. So let me